Hello, welcome everyone to your daily edition of Ask a Lawyer Live. I'm David Brannen, founder and managing lawyer here at Resolute Employment and Disability Lawyers. Today, you are here for our first ever call-in show where I am going to attempt to take phone calls from people and talk to them live on the show here, answering their questions. And of course, this could all just fail spectacularly. So if you're here with a morbid curiosity just to see this whole thing crash and burn, you may be in for a show. Hopefully it will work. We're still working the bugs out. This is the first week. I'm on day 4 of doing daily live streams. My goal is just to keep doing them 5 days a week, maybe the odd one on the weekend sometimes, but we're on day 4. Things are improving. I've gotten a little bit better lighting. I had an issue yesterday with the mic kind of affecting the focus on the camera. So we're improving every day. Hopefully once we get a few weeks into this, it'll be a much better user experience or viewer experience. And yeah, that's what we're trying to do. So let's start today. Before we dive into things, I do want to give a quick update before we dive into live questions. We'll give some time for people to show up. Yesterday, I believe, or the day before, I'm not 100% sure, the government finally dropped the regulations for the new Canada Disability Benefit. If you're not aware what that is, it's the newest benefit that is going to be available for people with disabilities in Canada. It's a federal benefit, and it's been talked about for quite a while. It was passed last year in terms of the law, but none of the details were worked out because they were all coming in the regulations. While we now have the regulations, the final regulations, and we know now what this benefit is going to look like. And I'll just give you a quick little overview right now. But I do want to let you know that tonight, you see it scrolling at the bottom of the screen here. Tonight, I'm going to do a special live broadcast where I'll go over the regulations and take people's questions. I don't want to get caught up in it this afternoon, because I haven't had enough time to go through everything. So what I'll do when this stream ends, I'll have some supper and then sit down, review everything, and prepare to go back live tonight at 7:30 p.m. Eastern or 8:30 Atlantic, depending on where you're watching. I'll just give you a little taste of what's to come this evening. So hold on here. Here we go. The new regulations are going to clarify some key things like who is eligible for this new Canada Disability Benefit, how much will be paid. We kind of already knew that, but the regulation kind of sets it out in stone. Income thresholds. So what threshold of income will prevent you from getting this benefit? It's not available to everyone. Whether there's an annual inflation adjustment, when the program starts, if you can get retroactive benefits, and what tribunal or tax court is going to take care of dealing with these claims. All right. Those are things I'm going to cover tonight. If people had questions today, I can answer limited questions, but I would really urge you to wait and give me a little more time to finish reviewing everything, and I'll be discussing these tonight. Like I said, I'll just be back live here on YouTube and Facebook this evening. Okay. Let's go. Let's see if this is going to work. So let me just talk about it before people start calling in. If anyone calls in, maybe we won't have. I didn't bother to set up a fake caller just to see if no one calls, then we'll keep doing this every week until someone's brave enough to call in. But before you do call in, just a few things. First of all, the purpose of doing this is to allow a better communication back and forth. Because you'll be speaking live, I'll be able to hear you. We can talk back and forth and get more details, give you a more in-depth answer to your question. This is not meant to be a private legal consultation, even though I'm getting more information and able to give you a better understanding and answer. It's not technically a legal consultation because it's not confidential and I don't have all the information I would need. And it doesn't mean that I'm your lawyer, just to give that disclaimer. What it's meant to be is a talk radio call-in show, like the old days, where I can get some more information and kind of answer your questions. If you want a confidential, answer or it's more detailed, then we would definitely not want to do it live on the air. I would encourage, if you do call in, that you not disclose, your personal information and things like that. You're just a phone call, so your image is not going to appear on the line or anything. Just I'll just be able to. People will just hear you talking as long as all the technology works. I've been trying to get it set up all week. You can also still answer questions just by typing them in. If you don't really want to call in today, that's fine. You can just type your questions in, and I'll take questions in the meantime, just typing them in the comments. I think that's pretty much it. A little out of breath here already. Let me get a little drink. Okay. Again, this is not guaranteed to work because I am a lawyer and I'm trying to get this thing all running in my spare time. So, but I think it is going to work. I tested it out a little bit yesterday. Hopefully this will work. So let's look at some of the questions we've got here already. Here we go. Here's a question. So this is from Yusuf. Good day. Can a retired doctor with an inactive medical license hired by workers' compensation provide a medical opinion on a claim, particularly in the field of mental health? That's a good question. I'll be completely honest. I'm not, off the top of my head, I don't know the rules around that for the doctor. Certainly, if the doctor is just reviewing medical information and giving an opinion to workers' comp or an insurance company, and they're not seeing you, they're not doing an assessment, I don't know that would be a problem for them because they're just giving an opinion. It would be no different than workers' comp dragging someone off the street and saying, "So these confidentiality forms, now we want you to review this file and give us your opinion on it," right? So I think where it would get into trouble is if that doctor was going to do an examination for you without being licensed, then that could be a problem. But again, I don't know all the details of your specific situation, but hiring someone for a medical opinion, if they're not doing an examination of you, may not be technically illegal, though it does open them up for some criticism if their opinion goes against a doctor who is licensed and has examined you. All right. It's another good question from Christina. Hi, David. I've been informed CPPD, Canada Pension Plan Disability, can pay additional medical expenses. However, I've not been able to find any information on this. I'll be honest. I think you may have been misinformed on that. Canada Pension Disability does not pay for medical expenses. So there might have been a confusion in that question. All that Canada Pension Disability provides is a medical benefit related to, it's a medical, but all it provides is a disability pension. That's it. There's no provisions within the Act or the regulations for Canada Pension Disability for them to pay for medical expenses, with one exception. Under their vocational rehabilitation program, they can authorize other expenses outside of just paying the benefit. So I don't know if that is what the person was referring to, although I doubt it, because usually again, that's going to be vocational type expenses related to returning to work. Not necessarily, those would not typically be medical expenses. So I think maybe that there was a miscommunication there, because I don't believe that you can get medical expenses paid through Canada Pension Plan Disability. Now, you can clarify that if you think I'm not thinking about it correctly, but that would be my thoughts right now. Okay. This person says, good afternoon. Please repeat what time you will be back online tonight. Okay. I'll show you right now. It's going to be, boom, right there. Live stream. You see it scrolling at the bottom there right now. So it's going to be at 7:30 Eastern time, 8:30 Atlantic. And I apologize for all my Alberta people. I just can't do the math on what that's going to be in Alberta. For whatever reason, I do a lot of work in Alberta. I've always had a lot of clients from Alberta, but I don't know the time there right now. So, but that's what it'll be. If you go by Eastern time, it will be 7:30 p.m. this evening. I do need to finish reviewing it and refreshing myself on the program because it's been a while since I've thought about it. And I do want to go through the new regulations and just kind of study them up a little bit, and so I can give you my thoughts on it. The good news is that just from my brief review of the regulations, the program is going to start this summer, and so that's good news. It was reported before that the program would be starting in July, so it is true that it will be going live by July, which is great. And benefit eligibility can start as early as June 2025, but the way benefits work, they can only be paid 1 month after the date of your application, I believe. So if everyone gets their applications in June, then the first month you could be paid would be July. And we'll be talking about that this evening. I'll be going over what the application process might look like, the amounts people can get, the different categories. Like there's a lot of information now. All the stuff we wanted to know is now available, for good or for bad. We now know all the information. And if you can't, for some reason, show up tonight, you've got other things going on, that's fine. It'll be recorded. This is going to be a live stream. So you just go to our website and go to the live section, and you'll be able to find the video this evening there. Okay, see, we got more comments here. If a doctor provides medical opinions without seeing a patient, still be valid or may not be valid? Again, I guess this is a very good question, honestly, Yusuf. I'd like to look into this more myself, but just going on my gut feeling, it's that they can give opinions. These would just be opinions to the insurance company or workers' comp on what, they are giving medical type opinions, but they're not providing medical care or doing a medical assessment. So I think this gets around this idea that if it's a retired doctor, they can still give opinions on, just looking at it. They're not going to give opinions necessarily on your treatment or anything like that. This is what I would anticipate. But whether it's valid or invalid, it's kind of open-ended. It really is contextual. Like this person is not going to be giving you medical recommendations for treatment and things like that. I would doubt that very much, but they could be giving us opinions on whether you meet certain criteria under workers' comp and that kind of thing. Again, I'm going just based on what you're saying, so I can't really comment on your specific situation, but just generally speaking, yes, if you are getting a medical assessment by a doctor, they have to be licensed. But if you're not getting an assessment, like they're not examining you and they're just reviewing information on your file and giving opinions, then there is probably some room for them to do that. But again, I would want to check. I'd have to double check on that with the professional regulations and things like that. Because I'm kind of talking off the top of my head here. So it's possible I'm incorrect, but that's what I think. Yeah, so it could, I can see where you're coming from. So you're concerned that they could base their decision on this unlicensed doctor and then deny your benefits. That's true. That is true. But you're able to appeal that decision. And by using a doctor who's no longer licensed, they are opening themselves up that it's easier for you to argue that your doctor should be listened to over that doctor because your doctor examined you and your doctor is giving opinions and is licensed. So it does strengthen maybe your appeal, but I don't think that it's illegal for them to rely on an opinion like that. Okay. All righty. I've got some questions here that I took from, as many of you may know, we also have for years, I've sponsored, and I mean, I own it, but I also sponsor it. It's something called the Canadian Disability Claim Forum. This has been around for years. I've gone on there and just taken some questions from there that I'll answer here today. So let's just look at some of these questions. One of the questions I saw in there that I thought would be good to go over with people is someone had asked, can my disability insurer force me to apply for CPP disability even if I want to return to work? So if you are on long-term disability, these insurers can be quite aggressive in getting you to apply for CPP disability. It used to be that they would wait until you were getting close to 2 years, but starting a few years back, they got way more aggressive, and they will start having people apply for CPP disability like almost immediately. Now, they do this for financial reasons because if you get approved for CPP disability, then they have to pay you less. And the way it works for CPP disability is that the longer you wait to apply, you miss out on past benefits. So somebody at the insurance company was crunching numbers and said, we could save X million dollars a year if we just started getting people to apply a few months earlier, because that might make the difference of several $1,000s in each case. And if you multiply that by thousands of cases, now we're into like hundreds of thousands and millions of dollars. So I don't know this for a fact, but I assume that's what happened. And so there became a directive down from above that these insurance companies started getting people to apply for CPP disability much earlier than ever before. And quite frankly, at times that are inappropriate. Like if you're still in your own occupation phase, you may have no desire to be on long-term disability beyond the 2 years. Your doctor may not agree with it, but you're kind of faced with a situation where the insurer is pressuring you to do it. Unfortunately, if you are involved with an insurer and they are pressuring you to apply, you really just have to do it. If you don't, they can start deducting your disability benefit by what they believe you would get from CPP. They're allowed to do that because of the way the policy is worded. So unfortunately, you have no choice but to go along and do this application for CPP disability benefits, even if you think that it's not going to have any merit and that it's not going to get approved and that you don't even consider yourself to be long-term permanently disabled. So that's the unfortunate answer is, yeah, you do have to go along with it and understand that's why it's happening. Okay, let's take a peek here. Here's another question from Jason. How hard is it to get the disability tax credit as compared to Canada Pension Disability? This is a great question. And there's not really a simple answer to this. It's not like objectively one is harder than the other. It really depends on how easy it is to prove what it is each of them are looking for. So they look for different things. Certainly, if you just want to take some general statements, the disability tax credit is looking for a higher level of disability than the CPP disability. CPP disability is looking only narrowly at disability that prevents you from working and earning a substantially gainful income. Okay. So you can be quite independent, but your disability is such that you can't show up to work on a regular basis and you don't have the ability to earn more than about $20,000 a year. So if you can't earn more than about $20,000 a year, if you can only earn under that, then you can qualify for CPP disability, even if you're independent in all other areas of your life. On the other hand, the disability tax credit is very focused in on quite severe level of disability with some area of daily living, like dressing yourself, feeding yourself, taking care of yourself, being able to walk longer distances, being able to administer life-saving care to yourself, like diabetes prevention or management, this kind of thing. So on the surface, I would think it's harder to get the disability tax credit from the point of view that you have to have a much higher level of disability. But if you have that higher level of disability, it is more objective in a sense, and you can easily just be approved. Whereas the ability to work sometimes or the inability to work, or the inability to work more than you're working, if you can't work enough to earn $20,000 a year, that can sometimes be harder to prove because it's a little more subjective. And that in many cases can make CPP disability trickier. So the answer is like, there's not really one harder than the other. It will depend on what evidence you have in your case and how easy it is going to be to show that you can't work a full-time job. All right. It's another question. I have two insured. One ready said that I'm approved to 65 or any improvement, but the other insured does not yet apply for both, or does affect one to the other. Let me just think about this here. So it sounds like this person has two insurance policies, maybe. one that's approved them until age 65, unless they get better. Um, and maybe the other one hasn't made. I'm not 100%. Maybe give me a little more. Rephrase that a little bit because I'm not 100% sure what you're asking there. Rephrase that a little bit, and I'll see if I can understand. Sometimes I can't get everything through my head. If anyone else understands what the person is asking, you can also type it in and let me know. But I'm not 100% sure what they mean there. All right. While we're waiting on that, I'll look at another question that I had from the Canada Disability Forum. Here's the one. This question comes up all the time. So, can my employer cut off my group insurance, my group health insurance, while I am still on long-term disability? Where you will see this come up is people off on long-term disability. They are often very dependent on having the medical, dental, not the drug coverage is usually the big one. It's the drug coverage is usually the number one thing that people need. And so if you're off on long-term disability, you may assume that you will be able to continue to get your group medical as long as you're on long-term disability, but that is actually not the case. There is really no connection in most cases between your long-term disability and the other group medical benefits that you have. Even though they kind of fall under the same group policy, they don't all have to continue along. Like the way the long-term disability is written, you're able to continue to get that over a long period of time, even if you're not employed anymore. However, the other benefits like the dental, the group medical, vision, and all that stuff, the drug coverage, most of those only apply if you continue to be employed or for a certain number of time if you are not actively employed. So what happens is it is very dependent on the employer and the deal they have with the medical provider, the group insurance provider, that these benefits can end. Sometimes it's as short as a year, 2 years. It can sometimes be a little more open-ended than that, but ultimately it's an issue between you and the employer on when they want to stop the medical coverage. As long as they're stopping the medical coverage in a uniform way for all employees, they're not discriminating between employees, then there's not much you can do about it. And you don't have a right to continue to stay on their medical plan. Sometimes you're not even allowed to. By the terms of the plan itself says that they'll only cover people on a sick leave up to a year or 6 months or 2 years. Sometimes what'll happen is you will get kicked off because for whatever reason, the employer has to renew their plan or they're changing group providers. Well, that will have no effect on your long-term disability benefits because they're kind of locked in. If they change providers, that can kick you off the plan, and maybe the new provider won't take on people that are already on a sick leave. So that is another reason why you can stop getting your kind of drug coverage benefits while you're off on LTD. It is possible for employers to do it. It's not illegal for them to cut you off, and it's not tied to your long-term disability plan. Only in unique situations where you maybe are in a union, but in a union environment working for the government, would there be a situation where you're guaranteed to keep the medical plan as long as you stay on long-term disability? Outside of government employees, I don't ever see that being the case. Okay. So this one is okay. So this person is saying they got 2 long-term disability insurance policies, I believe. One of them has approved this person to age 65. The other one is still up in the air. That is something that can happen, and it is common. You can have actually 2. It's quite common. Well, it's not quite common. It happens that people can have more than one plan, and these plans decide things independently. Sometimes they have different definitions of disability or different considerations. And it's not unusual that one plan can approve you and the other plan can take their time. So you can't really read a lot into it. It would be more that you just have to make sure that both plans have the same information and that you're getting all the information to the plan that has not approved you to age 65 yet. That's what I would say. They're independent, so they just make their own decisions, and sometimes they decide things differently. And it's possible there could be a different definition of disability, although that's usually unlikely. Usually they probably have a very similar definition of disability. Okay, here's one here. My doctor wants me to go shopping with my parents as a form of exposure therapy. Can I refuse this treatment? Okay. So, exposure therapy is quite common. It's for people who have anxiety or other kind of phobias who don't want to leave the house or interact in a public setting. And exposure therapy is the a proven way to help people overcome these types of disability. Now, as a general sense, it is not a good idea to refuse any treatment recommended by your doctor. What you could do is maybe negotiate with the doctor to structure it a little differently or roll it out, but you can't refuse to do treatment recommended by your doctor, because if you do, that is just a simple way for the insurance company to stop your benefits based on a policy violation. So insurance companies can stop your benefits if you don't meet the definition of disability, but there are other ways they can stop your benefits. Even if you meet the definition of disability, they can still stop your benefits if you have a policy violation. And all group policies pretty much require you to follow reasonable medical advice. And so if your doctor's making this recommendation, especially if it's your doctor, then you really have to go along with it. So I would suggest you do what I tell anyone to, when you're faced with something that you really don't want to do, is engage the process. uh, do this, go shopping to some extent with your parents to and report back to your doctor how it went. The whole idea of exposure therapy is that it's done gradually over time, so that you shouldn't try to like throw yourself in the deep end and going to the most busy shopping mall or grocery store. Just start with something very simple and easy, a store that may not be that busy or have a lot going on and that you don't have to be there that long. But I would encourage you to take a small step and try to then talk with your doctor about how it went and work with your doctor to figure it out. Very good question. All right. Here's another question I got from the Canada Disability Forum. So this caller says, I'll just read this off. My long-term disability was denied for a pre-existing condition. Do I have any hope to overturn the decision? Okay, the dreaded pre-existing condition. This is a tough one, and this word has a lot of different meanings to a lot of people. What is important for you to know if you are applying for long-term disability insurance benefits is that pre-existing condition, it is defined within your policy, and that is what it is. Do not try to like get someone else's opinion on what it is. Don't read about it online generally. Don't listen to a doctor saying what they think it is. This is a very unique thing to your policy, and it is a very what's the right word I'm looking for here? I want to say esoteric, but that's kind of a word. It's kind of a word you have to try to figure what that means. It means that it doesn't have any kind of common sense meaning. It's meant it's how what is a pre-existing condition will be whatever it is defined in your policy. It's very legalistic. It doesn't have any common sense to it. It's not what you would think in a general sense of what a pre-existing condition is. So, because of that, often there are loopholes to get around it, but it also means that it can be defined in a way that you don't expect. So, with most group policies, most group policies are not concerned about pre-existing conditions in the sense that you've had some condition in the past and therefore you can never be covered by, like, you once had a mental illness episode, therefore you could never be covered by disability for mental illness. That is a type of pre-existing condition exclusion, but that is not how most group policies handle it. If you have an individual policy, they can just exclude things forever. So if you have an individual disability policy, and for example, like when I got my long-term disability when I was in my 20s, I had an elevated cholesterol test. Didn't have high cholesterol, didn't need medication, but the insurance company jumped on that to say, we won't insure you for any, you have a pre-existing condition, so we're not going to insure you for any type of disability related to heart attacks or strokes or anything like that. Okay. So that's a type of pre-existing condition on an individual policy. However, with group policies, it works differently. They're only concerned with pre-existing conditions that you had treatment for, received treatment for, saw a doctor for within a certain period of time leading up to when you enrolled in the plan. They kind of look back for a period of time and just say, okay, you enrolled in this plan today. Um, or well, not today. They'll say you enrolled in the plan on January 1st, 2025. Well, what they will do is look back for any pre-existing conditions in the year leading up to that. It depends on the wording in the policy, but for example, a year leading up to that, did you receive treatment for the same condition or see a doctor over that year? If the answer is no, then you don't have a pre-existing condition. If you saw a doctor for it a year and 1 day ago, then you don't have a pre-existing condition because it did not happen within the window set out in the policy. So the policy will set out this arbitrary window of time that if you got treatment for the same condition during that time, then it is considered a pre-existing condition. So a lot of it with these cases is trying to determine whether any conditions you had or any treatment that you had within this window of time was related to your current condition. And that's where this all goes. Sometimes it's obvious, sometimes it's not obvious. But what you would do in these cases is you get the medical records and look at every interaction you had with the healthcare system in this window of time and figure out, was this directly or indirectly related to your current condition? And if the answer is yes, then it will often be considered a pre-existing condition. If the answer is no, then it will not be a pre-existing condition. But sometimes there'll be cases where it's arguable. So especially if these policies will say treatment that was directly or indirectly related. The indirectly can really open it up to interpretation. And that is where you'll get these fights over whether you had a pre-existing condition or not. Okay. It is, these are tough cases. We take them on occasionally, but they often are quite disappointing for people. With these types of cases, with pre-existing, you're fighting two battles. So one battle is, well, the first battle you're fighting is whether I'm even covered under this policy or not. Did I have a pre-existing condition? So you have to win that battle. If you win that battle, then you get to the second battle, which is, okay, you are covered under the policy. You didn't have a pre-existing condition. Do you have a total, do you meet the definition of disability? Now you're fighting over that. So you're fighting two battles, not good. And the problem with the pre-existing condition battle is that if you lose on that, you get zero. Like there's nothing. So a lot of these cases have to be, when they're settled, they settle for not a lot of money because of the insurance companies are confident that they have two kicks at the can, if you know that phrase. They got two chances to beat you. And if they feel strongly at all about the pre-existing condition argument, then they will not offer much money in these cases. They offer very low amounts. I had one of these cases settle about a year and a half, 2 years ago. Client was not happy at all. The problem we had is that her own doctor is the one that was giving the evidence supporting the pre-existing condition. So the insurance company was quite confident because they kept bringing up the fact that we're not relying on our doctor. Your doctor is the one that is given the evidence that it's a pre-existing condition. Now, of course, the client and myself both disagreed with what her doctor had said, and her doctor was, in my view, incorrect for reasons I won't go into. But ultimately, if you just, like the judge, we went to a pre-trial settlement conference. The judge just said, look, like, I know you're splitting hairs here, David, but you just have to step back and look at this. Her own doctor is saying she has the pre-existing condition. Like, most judges are not going to get beyond that. You're trying to split hairs. I'm sorry. If this were me, this would be a pre-existing condition and your client would get nothing. Right. So that is that when there's that kind of situation, it is very hard to get a good settlement in these cases. And people often, it's why I'm reluctant to do some of these cases, because after years of fighting, you settle for not a lot of money in the scheme of things. And people feel very they don't feel good about it. And then they don't feel good about their lawyer. The whole thing turns out to not be a great situation. So with these cases now, when I do take them on, I'm very clear with people up front that you have to have reasonable expectations of what's possible here, because these are the likely outcomes of this type of case. And if that's not good for you, then you should find a different lawyer or don't pursue this case at all. All right. Okay. Does ODSP or PWD use surveillance on recipients? So, for those of you who don't know, ODSP is the Ontario Disability Support Program, and PWD is Persons with Disability. I believe that's BC, British Columbia's. These are their provincial disability benefits programs. Do they put surveillance? I think in extreme cases they might. They might in extreme cases, but it's not a common thing for them to do, I don't think. But I would venture to say that they would do it. Yeah, usually all of these programs have fraud departments, and in certain cases, they would put surveillance on people and do investigations. Same with CPP disability. They don't do it that often, but they do have a fraud department and they will do investigations that can include getting video surveillance if they think there's fraud going on. So it's not like an insurance company that they will routinely do surveillance. When you're getting into these provincial programs and especially CPP, they don't do them routinely. Surveillance is quite expensive. I talked about this yesterday. Even insurance companies who you view as like they got millions and millions of dollars, they're even reluctant to just willy-nilly throw surveillance around because they don't want to spend the money either. And so with these provincial programs and with CPP disability, with workers' comp, they will do surveillance, but only in a very, unique situation where they've got a real, like what it usually takes is someone calling them up, like a disgruntled ex-girlfriend, boyfriend, husband, neighbor, saying that you're a fraud and they've got proof and that you should be investigated. Like, unfortunately, that is often how these investigations get started. And so hopefully you can avoid having your ex-spouse turn you in, so to speak. Even if you're not guilty, it can cause a lot of headaches because now you're being investigated and things like that. One thing I will say, I had this come up, is I once had a client and they left their spouse and went with someone else, but forgot, like moved out and traveled across Canada, but forgot to change their mailing address. So all their mail continued to go to their home address. So their spouse was getting all the mail from Service Canada and then was returning it and saying, this person is a fraud. They're out. So that is not good. So I would encourage you to change your address if you are going to be moving out, and don't let all your Canada disability stuff go to an aggrieved ex-spouse. Okay. I think I got another question here. Let me see. Oh, yeah. Here we go. So with this question, this one is, I got denied CPP disability and I didn't follow up on the appeals, but now I've thought about it and I've talked to my family and we realized I should have. Can I reapply again? This is a question that comes up. The answer to this is, for the most part, yes. If you applied for CPP disability and you didn't follow up on the appeals, and then what happens is if you don't appeal within a certain time, you lose your right to do so. If you've done that and didn't follow up, you technically can refile a new case. How it works is when you refile, it would be done under something called the what's the name? Oh my dear, drawing a blank here. The late application provision. How did I forget that? You would be filing under the late application provision, which means you're filing an application now, but it's for a disability that started sometime in the past, and you're able to do that. Now, certainly they're going to look at it they don't like it when people do this, and it's quite important if you do file a second application that you get all the paperwork related to your first application so that you keep things consistent, because you're still applying, even though you're applying a second time, you're still applying over the same period of disability. So things that you said about yourself back then, you'd have to make sure you say the same things now or have good reasons to clarify why it's different. So if we have a representative, we do represent a fair number of people in this spot, because people will try to do it themselves and then they're not able to follow through on it. They just get, there's such a high number of people that apply and then don't follow up with it because they get discouraged, and there's a million reasons why not. We will always request before we start the new application, we will always request a copy of their old application and all the notes from Service Canada around the first application so that we can do a better job with the second one and make sure that everything is consistent with what was said before and we know what the concerns were before. And the only time you can't do this is if you have a final decision. So if you did do the appeals, you got to the tribunal, and the tribunal issued a decision. That decision, you can appeal it, but if you miss the deadlines to appeal it, or if you don't appeal it, you cannot apply again later for disability. That would be covering the same period of the decision that was done by the tribunal. So the only way, if you have a tribunal decision, the only way to reapply successfully for CPP disabilities, you would have to re-enter the workforce after that decision and work 4 of 6 years and then reapply based on a new disability that started after the decision of the other one. Okay, so that's a very difficult thing to do. I don't know of anyone that's ever been successful on that. But the short answer is yes, you can reapply. Now, you can't just spam applications like apply, denied, wait, reapply again, reapply. They have the ability to just not accept applications if they feel like someone is abusing the process by just repeatedly refiling applications and not following up with the appeals. They can just refuse to accept your application if that starts to become the case. So you don't want to be that person. Yeah, you're welcome. I love doing the show. I do them every day. I'm getting used to it's getting easier every day. I rewatch them to say, oh yeah, because I have to rewatch it and see what the mistakes were. Like yesterday, for whatever reason, the camera kept focusing between me and this mic and going and zooming in. So it was just kind of real annoying. I also had a lighting problem that I'm hoping is fixed to a certain extent, although it looks like I might still be too dark. So I was just overexposed with light. My wife said I looked like some type of a glowing, I would say an angel, but she didn't say an angel, but just this glowing thing where it was hard to watch. So I've tried to fix that. I'm not a professional videographer and I'm just trying to do this myself. I mean, I could try to get someone in here to do it, but a lot of things you can just learn by watching YouTube and trying to do it yourself. So that's what I'm trying to do. Recognizing it's going to take a month or two to get this thing going real well and to have good quality in terms of audio and also video. Okay, here's another good question. How is going back to school or work, having a baby, and going on a vacation bad for your claim? Well, let's deal with each of these in order. So, going back to school or work is bad for the claim because it is evidence that you are capable of work. If you're capable of doing schooling from the insurance company's point of view, you're capable of working. And so that is why most insurers will not pay long-term disability benefits while someone is going back to school. There are exceptions. There are exceptions, but they're very limited exceptions, and you probably shouldn't anticipate that they would apply to you. So I have seen in unique situations where insurers will pay for someone to go back to school, but typically those are going to be that you have a plan with a large company that's more of like a self-insured type plan, or you work for the government or something like that. Those are situations where you might have some exceptions and they will pay for training, especially if you have a very high income and your LTD would be very high for them to pay for the rest of your life. But that is why. So it's evidence of ability to work. Now, having a baby, it's funny that you say that because it's kind of a running joke in our law firm. Like one of the cardinal sins is if you have a baby that you must somehow not be able to be disabled. So the thing with why insurance companies are very fixated on someone having a baby is they now worry that you're just going to use long-term disability as a glorified maternity benefits program, that you're just going to get paid on long-term disability to stay at home and look after a child and live happily ever after. That's what they're concerned about. So, and they think that if you have a child at home and you're looking after them, that you have no incentive now to try to go back to work. So it really will throw them for a loop. Also, if you are on the other hand as well, they feel like if you are staying home caring for a child, then you should be able to work. That's another view that they will take. If you're capable of caring for a child, especially an infant, then you should be able to work as well if you're able to manage that. So they will use that kind of evidence as well. Now, what was the third part here? Going on a vacation. Okay. The vacation is the least of these. The vacation is the least of these. So I encourage anyone on a long term disability claim to go on vacation with some limited exceptions. Those exceptions would be like, don't do a vacation like within the first few weeks or months of your long term disability claim. That's just going to look really bad. And I would highly recommend against it. However, once you're on a claim and your treatment is set so that you are getting treatment and that a vacation would be determined not to interfere with any program that you had. So it's not a situation where you have to show up every twice a week for physiotherapy. Like you do not want to take a vacation and interrupt a physiotherapy program where you're having to show up every week. Not a good idea unless it was only for 1 week and you work things out with the therapist that you could do the treatment while you're on your vacation. Like those are the kind of things you would want to do. But again, vacations, the insurers just don't like them. They don't like the idea of people, I guess, having any type of quality of life when you're on a disability. They will bristle at vacations because they see if you're able to go on a vacation, you can go through an airport, you can sit on a plane for all this time, you can now walk around see all these sites, like you should be able to work. That is just the idea that they have in their mind. And it's very hard to shake them off of that. What I recommend for people on vacations is that who want to go on a vacation is one, make sure it's not like at the start of your claim when you're still getting active treatment. Once things have kind of leveled out and you're not having to show up for an appointment every week, you can absolutely go on a vacation. What I would recommend is you talk to your doctor about it and have your doctor write a note that you can give to the insurance company, a little letter saying that you have discussed the idea of a vacation with them. They are supportive of it. They think it'll be good for your health, that you're capable of doing it, and that it will not interfere with your treatment at all. Then you give that note to the insurance company and go on the vacation. That is what I recommend. What I don't recommend is doing the vacation, not telling the insurer, letting them discover it somehow. Then now when they discover things, they already feel like maybe there's something sneaky around this. What aren't they telling us? What were they hiding? Like if they discover it, they feel like there's something fishy going on. If you tell them ahead of time, then you take the wind out of it and they're aware of it, right? There's nothing to hide. The problem with vacations is people will post pictures that maybe don't accurately surprise, surprise, social media is all fake. We know that now. In the early days of social media, I can remember a lot of judges who were older at the time and who were not savvy at social media at all. They would think everything on there was real and that they didn't realize people have like phony personas and phony life and everything else. Now that's better understood. But even with that being understood, just the power of video and pictures it can be twisted against you to make it look like it contradicts what you're saying about your abilities and your quality of life and these kind of things. So just be aware of that. Be aware of that. Many people get in trouble because social media goes against what they are saying their limitations are and their abilities. So be careful on a vacation. Not just you, but some insurance companies, they'll watch people you follow to see if you're tagged in photos and things like that. And the tagged in, you can just be seen doing things like if you're seen going down, you have a very significant disability that's physical, and there's pictures of you whitewater rafting and climbing up mountains and things like that is not going to go well for your claim. Now, if you have a mental disability and you're doing those things, it's not necessarily as big a deal. So it all depends on your case, but vacations are definitely a sore spot for insurance companies. Okay. This one says, how much percent to win with surveillance? I think what you're asking is like, how good is surveillance like a very big deal? Does it help the insurance company win cases? I would say that for the most part, most of the surveillance, at least that I see, is not that impactful. Now, when it is impactful, it's big because it's visual and there is this idea that a lot of people have that people do cheat and lie about disability. So if there's something on video that feels like a gotcha, then a lot of people will be very inclined to believe it, and the surveillance can have a lot of weight and have a, can really help the insurance company. But most surveillance just does not really go that far. It doesn't help. And sometimes it hurts the insurance company when it looks like they're harassing someone who obviously has problems, and the what's on video is just what their abilities, what they can say they can do. Like a famous example in Ontario, there was a case over the last 2 years that really blew up in the face of the insurance company. They had hundreds and hundreds of hours of surveillance, and it all blew up in their face because the jury got sickened by it. The lawyers for the insurance company were playing like hours and hours of surveillance day after day after day, and it had the reverse effect. They thought the effect would be that the jury would now see this person as like, but what happened is it was the reverse. They became sympathetic. They were disgusted that they were doing surveillance when this person was with their grandchild. Like, so there were all these things where it can just blow up the other way. But it can. I've had surveillance be quite effective. I've had surveillance when I got it, I've had to talk to my client and say, there's no, this case is over. Like there's no going back. But that's when there's like a contradiction that you just cannot explain with any innocent explanation, then the whole case gets blown out of the water. Certainly when the insurance company feels like they have powerful surveillance, that will lead them to like lowball, not approve the claim. That's why some cases can go to trial over surveillance, because the insurance company will just not offer much money to settle the case. They'll be very fixated on the surveillance. Now that is changing because of this, like I said, the big case in Ontario where it blew up in their face. But I still get surveillance on cases, and it can be powerful then sometimes. But I think for the most part, more likely than not, it's not going to have a lot of judges, a jury can go certain ways with surveillance, but a lot of judges they've been around the block. They know how things work. It's going to take something quite significant to be impactful on a judge. Okay. Get near the end here. This one says, what about moving while on long-term disability? Technically speaking, most long-term disability plans are not going to have clauses in there that prevent you from moving. However, as long as you stay within the country, you should be fine. But if moving means that you lose your job, so if you have to quit your job to move, even though you're not working there anymore, if you still are employed. So if you move and have to get rid of your old employer, the LTD will not like that, because they know the easiest way to get someone back into the workforce is with an employer they already had, because they already know you. The current employer has obligations to accommodate your disability. And so if you move and leave a very favorable work situation that you might be able to return to work to, and now you're having difficulty going back to work, like the insurer may try to hold it against you and say, well, it was your choice to move. We think you would have been able to go back to your old employer. The fact that you can't find another job is not our fault. So that's more the issue, is around that. But there's not usually restrictions on moving within the country. There are restrictions for moving out of country. And for most group insurance policies, it's prohibited. That if you move out of the country, or if you go out of the country beyond a certain number of days or weeks, that the benefits will just stop. But there are plans, mostly individual plans, that allow you to move anywhere. No big deal. All right. I think I'm going to leave it there. We're getting close to the hour. So I'll leave it there for today. I'll just say again that I'm going to be, it's sort of flashing along the screen here, I'll be live tonight to talk about the Canada Disability Benefit. I need a little break here to get something to eat, and then do some research to get myself all brushed up and ready to talk about it this evening. So hopefully I'll see some of you folks back here. If not, you'll see the recording. It'll be on there. And I'm sure that I'll be talking about the Canada Disability Benefit going forward into the future. Thanks, everyone, for showing up. I do wish you all the best, and I will see you back here tomorrow. Oh, yeah. So I'm going to go live stream tonight, and tomorrow I have a guest on who is Jen Shea. She is the head of our support team and intake department here at Resolute Legal. We're going to be talking about what's involved with calling a law firm for the first time about a potential case. How do you go about it? What to expect, and to give you kind of a behind the scenes look at what law firms look for when they're taking on a case, why they might reject a case, and how, as you, the person calling in, can have the smoothest experience. So Jen and I will be talking about that tomorrow at 4. I'll be live tonight. Otherwise, I'll see you all back here next week as well. And we'll have our email going out at the beginning of the week telling you what all the topics are going to be. Take care, folks. Talk to you later.